I was reconsidering what I called reconsidering racial profiling. And I want to use as a focus for this paper the recent case of Hale Michael and others in Victoria. It was a case of racial discrimination against the Victoria Police. And I want to use it to outline what I see as some of the problems and limitations around the concept of racial profiling. Now, racial profiling is a concept that's not been used particularly frequently in Australia, and as far as I'm aware, this is the first case or first complaint of racial discrimination against an Australian police force which has specifically raised the issue of racial profiling in the context of racial discrimination. Certainly there have been other cases using state and federal legislation complaining about racial discrimination involving police services in various states and territories, but this is the first one that's articulated that complaint within the context of racial profiling. So this case against the Victoria Police was brought to the federal court by Hale Michael and others, and it settled in Melbourne on the 18th of February this year, so it's only just recently settled. It settled on the day that the trial was set to begin. The trial had been set in the federal court for 8 weeks, and basically the Victoria Police came to the party in a settlement. The police denied the allegations of racial discrimination, but part of the settlement to the proceedings involved an undertaking by the Victoria Police to conduct an inquiry into their policy of person checks, in other words, their policy of stop and search, and also their policies around cross-cultural training. Now, the court, the case against the Victoria Police was initiated some 5 years previously to that settlement at the beginning of this year. The applicants had alleged that the applicants were living in Flemington and North Melbourne, in public housing areas of North Melbourne at the time, and they alleged that during 2005 to 2009 they were stopped, questioned, searched by police in circumstances where a non-black or non-African member of the community would have been less likely to be stopped. All the applicants were of African background. There were 6 applicants in the final matter. When the matter had begun 5 years previously, there'd been 17 applicants, and 11 of those had dropped out during the course of time leading up to the settlement. The applicants alleged that the actions of the Victoria Police constituted racial discrimination and racially offensive behaviour under sections 9(1) and 18(c) of the Federal Racial Discrimination Act. Excuse me. And as I noted, the Victoria Police denied those allegations. And part of the complaint, a core part of the complaint, was that the African Australians had been subject to racial profiling. So it was the case of Hale Michael and others against the Victoria Police. So what I want to do with the time is just talk a little bit about the claim in relation to racial profiling, some of the statistical evidence that was used, say something about the concept of racial profiling and some examples of racial profiling in Australia, including the use of move-on powers, the use of arrest versus summons, excessive force, say something about the racial and ethnic minority groups in general that have raised this issue, and really come back to this final point about racial profiling and about the concept of racial profiling and whether in fact it is a useful concept. As I say, whether we decide in the end that it is a useful conceptualisation in terms of understanding police activity, I think is something that's open to debate. But having said that, I think partly as a result of the way the Racial Discrimination Act works is that we're likely to see ongoing complaints of racial profiling. So I think partly in terms of the litigation strategy that lawyers may employ in relation to complaints from citizens against police, we're likely to see the use of the notion of racial profiling, irrespective of what we might decide as academics or as researchers in terms of its actual conceptual usefulness. And I think there's also a broader issue here as well, that we can talk about policing and human rights, but ultimately there are also important questions about access to justice. I mean, what access do we have to a legal system to actually enforce human rights where there are violations or allegations of violations that have occurred? You'll be pleased to know it's not going to be death by PowerPoint. These are the only slides, so you've only got 2 to look at over the next 25 minutes. Okay, so the claim. As I've noted, the 6 applicants were all of African background. During the time that the alleged events occurred, they were aged between 13 years and 20 years of age, and 5 of the 6 young men were juveniles at the time, and they all lived around the public housing area of North Melbourne, Flemington and Kensington. The children and young men complained of assaults in public places, including being thrown to the ground by police officers, having a finger purposefully broken by police. The applicants complained of the use of excessive force during arrest, being punched, kneed, tackled to the ground by police. For example, Daniel Hale-Michael, one of the applicants, alleged that he was kneed in the testicles by a police officer while being arrested, and he was 15 years of age at that time. They also complained of assaults during detention, including being punched, pushed against a wall, held around the neck and choked, and again being tackled to the ground. Each of the 6 complainants complained that they were regularly stopped and questioned and searched by police when they were gathered in public places or walking in public places because of their racial and ethnic background, rather than on the basis of reasonable suspicion, objective evidence, individual behaviour or any other legitimate police purpose. One young man claimed that he'd been stopped on at least 73 occasions over the period. Another, Maki Issa, complained that he was asked by police for his name and address on at least 100 occasions in the 2-year period between 2006 and 2008, and he was aged between 16 to 17 during that time. As he recounted in his evidence, he felt that he was lucky to go a day without being stopped at least once by a police officer around the public housing estates at Flemington. He was only stopped when he was either by himself or with other African boys. When he was with his Caucasian friends, including on the Flemington estate, he was never pulled over by police. 2 of the 6 applicants also complained of racial taunts and abuse by police. So the case brought by Hale-Michael and the others alleged assaults in public places, the use of excessive force during arrest, assaults in detention, and frequent stoppings, questioning and searching, and that these practices arose as a result of racial profiling by the Victoria Police of members of the African community. Now, in terms of the statistical evidence, much of what I've got to say, much of this debate is drawn from the expert evidence that was used by both the complainants and the respondents. So the Victoria Police had their own experts to talk about the issue of racial profiling, and the complainants had expert evidence in relation to racial profiling. I was one of a number of people that provided expert evidence. The statistical evidence in relation to this case was prepared by Professor Ian Gordon, who's a statistician at the University of Melbourne. I don't want to go into too much depth in relation to the statistical evidence, but the point I do want to make at the beginning of this is that the experts on both sides recognised very clearly the limitations of the statistical evidence that was available in relation to the case. And I think this is an important point, and it's one that I want to come back to at the end. So Gordon analysed 6 data sets that were made available by the Victoria Police, and just very briefly, what he found in relation to that was that there was overrepresentation of African males in that area based on the recorded interactions. There was also overrepresentation of individual African males that were referred to in the files, and that was statistically, the overrepresentation was statistically significant across all 6 files that he had access to. One of these files contained information on involvement, and the majority of the categories that were used in that file related to whether the person was an offender or not, and the analysis of that showed that African males that were identified as offenders in those files had significantly fewer offences recorded against them than non-African males. So police contact with African male offenders was likely to involve individuals with fewer recorded offenders than males from other ethnic backgrounds in that area. Another file identified police contacts And again, in matching that with the other file that recorded offenders, it was found that in terms of field contacts, non-African males were less likely to be recorded in terms of field contacts than the African males. Most of the field contacts involved person checks, and the vast majority, 90% of those person checks, 90% of those field contacts involved person checks, and most of those involved the African males. And again, right through this, in terms of the evidence, there was statistical significance. So the evidence showed that African males who were classified as offenders were more likely to be stopped for person checks than male offenders from other backgrounds. And it didn't appear to be the case that African males were coming into police contact for person checks because as individuals they were more prolific offenders than males from other backgrounds. Gordon analysed the average number of field contacts and again found that there was a greater average number of field contacts for African males compared to other ethnicities. And in terms of individuals, African male offenders were likely to have person checks at 11.5 compared to 6.7 for the non-African males. So I don't want to go into this into any great detail, but only to say that all of this was shown to be statistically significant, and so not only were individual African male offenders more likely to be stopped for field contacts and for person checks, that is stopped and questioned and searched, than other groups, they're also more likely to be stopped with greater frequency. So this was seen to be at least consistent with police engaging in racial profiling. The question about proof is something that I want to return to at the end of this paper because I think it is a difficult area in terms of the concept of racial profiling and its use in litigation. There was also analysis of a text field that was associated with these stops by police, and a number of the remarks that were entered into that text field were analysed, and again, in relation to African males, it was much more likely that they would have nil reason or no reason recorded in relation to the person checked than males from other backgrounds, and again that was statistically significant. So I just want to step back from this for a moment and go back to this concept of racial profiling. Well, what is racial profiling as a concept? In terms of litigation at least, the concept really it's predominantly US based and it dates back to an early 1990s case in relation to New Jersey and Soto, which many people here will be aware of, where a New Jersey judge commissioned a study to determine whether state troopers, in terms of stopping motorists, were engaged in a process of racial profiling. And in that case, the African American males had alleged that the motivation for traffic stops was racial profiling. And the central question in most of the subsequent US cases has been whether the police have enforced the law to the benefit of all members of society or placed racial minorities at a special disadvantage. So I think in the academic literature, when there's discussions around racial profiling, it's tended to be associated with the development of drug courier profiles in the 1980s, and there's a line of research and academic discussion in relation to that. But if we're looking at it more specifically in relation to litigation in the US, then it really dates back to, and it's been primarily associated with motor vehicle stops by police. In terms of defining racial profiling, it's generally accepted that it's the adverse use of police discretionary decision-making based on assumptions concerning the racial characteristics of individuals. It involves police making decisions to initiate contact with individuals on the basis of their race or ethnicity, and those decisions usually involve stopping, searching, questioning, the use of move-on powers. It can involve harassment, racial taunts, the use of excessive force. And I think it's also possible to see later decisions, adverse decisions and adverse use of police discretion after intervention, and they may be adverse use adverse use of decision-making in relation to arrest and charge rather than summons, or in the case of young people, the failure to use diversionary options such as warnings, cautions, youth justice conferencing, whatever particular diversionary options might be available in a specific jurisdiction. So racial profiling, at least in litigation, has required the demonstration of the discriminatory effects of police stops, and that's been based on a comparison between police stop data and some sort of acceptable benchmark. And again, the issue around benchmarking has been a point of key debate, particularly in litigation around racial profiling. There's common acceptance that the definition of racial profiling involves the adverse use of police decisions on the basis of race and requires that race is a factor which predicts police decisions over and above other considerations such as crime, social conditions, economic conditions and police resources. And again, that raises a very significant issue in relation to proof. In terms of racial profiling in Australia, it's not a concept that's been used in Australia. It's difficult if you go back and do literature searches to find anyone that talks about racial profiling in the context of Australia. But I think it's what tends to dominate the discussion in Australia has been around issues of institutional racism, over-policing, racist violence, racial discrimination. And I think really racial profiling is a subset of those broader conceptual frameworks that have tended to dominate the literature and research here. I think, though, although it's been infrequently used in Australia, there's certainly a substantial body of research that would indicate particular activities by police could be seen within the definition of racial profiling. And I've just given some examples there. Stop and search, move on powers. There was considerable investigation of the use of stop and search under the Police and Public Safety Act in New South Wales by the New South Wales Ombudsman's Office and through other evaluations, and certainly in those cases it found that the use of those powers were predominantly used against juveniles and they were also used in a highly disproportionate way in towns with large Aboriginal populations. And in those particular situations, those searches tended to be unproductive. That is, the person was not carrying a prohibited implement, which was the reason for the search in the first place. So in places like Burke and Brewarryn and Moree, for those of you from Australia that are here will know are towns with large Aboriginal populations in New South Wales. The figures were of 90 to 95% of searches that were undertaken of young people in those towns were unsuccessful. That is, there was no prohibited implement that the young person was carrying. Use of move-on powers. There's been a number of reports. I'll just refer to one in Western Australia this time, the Law Reform Commission report in Western Australia and its investigation of the use of move-on powers in Perth. And again, a very clear concern that move-on notices were being used against Aboriginal people in, quoting from the Law Reform Commission's report, inappropriate circumstances, that they were disproportionately affecting Aboriginal people, that it appeared that Aboriginal people were being targeted by police for congregating in large groups in public areas, although no one was doing anything wrong, and that it was, according to the Commission, apparent discriminatory treatment. There have been other examples in relation to move-on powers in New South Wales and the problems in their use. I won't go into those now. Arrest and summons, again, the apparent preference in relation to the use of arrest over summons when proceeding against Aboriginal people has been noted in the literature. It's also been noted in a number of cases. The case of Carr, New South Wales Supreme Court case, where it was found that it was inappropriate for powers of arrest to be used for minor offences where the defendant's name and address was known, where there's no risk of him, in this case, departing, and where there's no reason to believe that a summons would not be effective. And the court found in that case that arrest is an additional punishment involving deprivation of freedom and frequently ignominy and fear, and can lead to an escalation situation. Use of excessive force. Just one example in relation to that was the finding of the Race Discrimination Commissioner in the early 1990s in relation to police activities in Redfern, and that raids in Redfern were legitimised on the basis of race, and the use of excessive force in those raids constituted racist violence, intimidation and harassment. So most of those, all those examples that I've just given relate to Aboriginal people. They don't relate to people from other racial or ethnic minority groups within Australia. And I think that also says something in terms of, I guess, the lack of evidence, the lack of research around this, and also the lack of litigation to some extent in terms of other racial minority groups. Given the time, I won't go into any great detail, but I will mention one piece of work that was done by the Flemington Community Legal Centre in Melbourne. It was a study of 151 young people from diverse racial backgrounds. It found the findings were particularly relevant in relation to African young people who were interviewed as part of that group. And African young people in Melbourne that were interviewed certainly experienced more difficulty with police than other youth. They felt that their treatment by police involved heavy-handed experiences and violence in some cases, and felt that they were racially targeted. And just very briefly, that report found that African young people complained more than other young people being stopped by police, they experienced heavy-handed treatment by police, that they were more likely to report a negative impact as a result of police behaviour, that they felt that they were more likely to feel that they were stopped by police because of their race, and they were more likely to be worried about constantly being stopped by police than other young people that were interviewed during that survey. In the final part of this paper, I just want to come back to this question then about some of the problems of racial profiling and the expert evidence that was used in this case on both sides, both the police side and for the complainants, really highlights some of the points, some of the difficulties, if you like, about how we prove racial profiling, particularly in relation to litigation. Police expert evidence in that case considered whether there was evidence of direct causality between racial identity and police intervention. And not surprisingly, they found that there wasn't. The expert evidence for the complainants was asked to consider whether the statistical findings that were presented were consistent with the definition of racial profiling. So there were two very different approaches that were undertaken by both groups of experts, one looking for a causality model, the other looking for consistency. And so not surprisingly, the bodies of expert evidence were at odds with each other in terms of the way they presented the material. The point that I think I'd make, though, is that on the basis of the research and the litigation in the US that's already been undertaken, it's unlikely that a scientific model of causality will be satisfied. You know, at best, a finding as to whether racial profiling has occurred or not is going to be based on a combination of quantitative and qualitative material, both of which are likely to have a range of shortcomings. The quantitative material to begin with is going to be limited, restricted by the range of administrative data that's available, by the technical factors that are related to the collection of that data, and by the sorts of the administrative priorities that the organisation itself has in relation to collecting data. And I think it's very difficult to prove statistically on the basis of the data that's available, that's collected by police, as to whether racial profiling occurs or not. In terms of some of the conceptual issues, the evidence for the police presented a long list of potentially relevant variables to explain police behaviour and what would be needed to determine whether racial profiling occurred or not. And I think it's, the problem is that you always have that debate about whether, what variables were ignored. Even if you manage to identify a wide range of variables in an attempt to prove racial profiling, there's a methodological difficulty of controlling for those. And also, by and large, as I've already indicated, the data is largely administrative data with all the shortcomings that we know arises because of that. Expert evidence for the police looked at other explanations for police behaviour other than racial profiling. And I think one of the problems with that was that there wasn't a consideration that some of those other explanations themselves might be consistent with the occurrence of racial profiling. So police expert evidence raised location as an explanation for police behaviour. The police behaviour could be explained by the location. But I think The literature in Australia in relation to move-on powers and some of the US literature shows that policing in particular locations is itself dependent on what could be seen, or consistent with what could be seen as racial profiling. So the stopping of black or Hispanic drivers in predominantly white neighbourhoods is about policing a particular location, but it's not inconsistent with the occurrence of racial profiling. The same with the use of move-on powers in relation to Aboriginal people. It's the policing of particular locations, usually in the central business district, shopping centres and so forth. So it is the policing of a particular location, but it's the presence of specific minority groups within that location that's part of the policing issue. The other question about benchmarking, I mean, there's considerable debate about what constitutes a reliable and sufficient benchmark. And I think, again, that's going to be continually problematic, partly because of the conceptual issue around the application of a benchmark assumes that there is a norm, that there is a norm or a standard which is applicable and against which you can measure difference. And that's a highly complex, I think, issue to raise, and it's one that's been debated in feminist research. It's been debated in a range of areas in sentencing. I mean, how do you conceptually define a benchmark against which you measure difference? There's also the issue about the question of proof. I mean, it seems from the court cases in the US that the courts have been willing to accept, or they do accept, other evidence rather than simply quantitative evidence. And in a sense, in relation to litigation, the court takes the role of the researcher in terms of weighing the various evidence that's brought, whether it's quantitative, whether it's what we might call qualitative, or in fact the statements of witnesses, and makes the decision on the basis of a range of factors rather than simply the quantitative data. The expert evidence for police argued that there was the need to use a number of different sources and triangulation of research findings to be able to demonstrate racial profiling. And again, the problem is there that you're not setting up a research program. You're not setting up a prospective research program as to whether racial profiling occurs or not. What you're dealing with in litigation really is a retrospective assessment of the evidence that's available, and that evidence will be drawn from a number of cases. So just to finish up with, I want to go back to make a couple of comments in conclusion about racial profiling. Whatever we think about the limitations of racial profiling, I think now that's been raised at that level, it's one that will continue to be raised, at least in relation to litigation in Australia. There's a sense, and it's been argued in the US that racial profiling is a new concept for an old phenomenon. We might attribute it to drug courier profiling or post-9/11 war on terror and the focus on racial profiling, but certainly some people in the US have argued that you could see racial profiling, if you want to apply that concept back, in racialised policing and slave codes or the post-Civil War Jim Crow laws. I mean, you could argue that you could see it in the policing of Indigenous peoples back to the early part of the 19th century in Australia. However, the nature of litigation and the nature of the Racial Discrimination Act in Australia means that racial profiling may well continue to stay alive. The Racial Discrimination Act requires, to demonstrate racial discrimination, that the act has been undertaken by a person. A person did the act. So it's immediately it's an individualising process that it requires, and racial profiling seems to fit within that much more comfortably than concepts of systemic discrimination, indirect discrimination, institutional racism, and so on. There's been very little litigation in Australia in relation to indirect discrimination, where you might be able to raise concepts of institutional racism or systemic discrimination, and by and large the very few cases in relation to indirect discrimination have been quite limited, and as far as I'm aware, there's been no cases in relation to indirect discrimination in Australia that have involved criminal justice agencies. The final point to finish up on is that Part of the problem itself in relation to litigation is also stemming from issues relating to police complaints processes. So this litigation in particular involving Hale Michael and the others began after the Flemington North Melbourne Community Legal Centre had lodged 17 complaints with the Police Integrity Commission in Victoria, and none of those 17 complaints were found proven by the Police Integrity Commission. So in a sense, if we're talking about access to justice and enforcing and respecting human rights, the move from the failure at the police complaints level into federal litigation, I think, was seen by the lawyers as the only way to address and redress the issues that have been raised by the African young people in terms of their experiences in policing. Okay, I'll finish at that point. Thank you.